Hello and welcome. This is Grant Hughes of Grant Hughes Investigates on YouTube. This channel evaluates all aspects of true crime. As you are aware, videos and live streams in this genre often discuss elements of crime that may be disturbing to some viewers. If necessary, take the precautions needed to avoid these feelings. Factual information related to cases is the key to fostering rational true crime discussions. Fortunately, you will find that here. Please hit the like button only once, share the video, and subscribe if you like my content. Thank you very much for watching.
We are all Richard Allen! Huh? You pieces of shit got to the jury, didn't you?
Yo, what the hell's going on, freaks? Hey, who knows? 13 months, thank you. I got my Breathe Right nose strip on, see that? I was actually using it for exercise, and then I went, oh shit, I got a breaking news, so I forgot to take it off. Alright, here we go. Those things work great. You guys ever used one of those? Get your new Breathe Right nose strips. Like it just goes. Yeah, this is breaking news. Breaking news, as Luckner would say. Breaking news. Breaking. Yeah. All right, here we go. Here we go. I know, they're awesome. Yeah, they're incredible. Alright, well, it looks like there's some new information out there. I got a bunch of different PDF files from the clerk over there in Allen County. I think it's Allen County Courthouse. And there's actually a couple, 3 images of Libby's cell phone. Now you can see why the port seemed to look like a jack was plugged into it. I mean, look at this. That's exactly what we were saying. Isn't it weird when you're just trying to be accurate, you can get the right information? Look at that. Hold on, let me get the JPEG's easier to look at. See that? Look at how it's all damp and moist, and there's little some sand over here and shit like that. Doesn't that make more sense then, that the jack actually had a little bit of moisture, maybe a little sand or something like that, and that's what created the connection really early in the morning? Look at that thing. And it's interesting to me that there's leaves on top of it. It's almost like the person sort of, whether it was Abby or Libby, I don't know how that would work. Maybe Abby, when she was moved over to it or moved herself there, I don't know how she got where she got, kind of slid the leaves on top of the cell phone. Hey, thanks, Timothy Cecil. Alright, so let's see. I mean, there's a few more images of it. Let me see if... and then the main thing here is the state's response coming up here. But it sounds like they might be releasing the audio from his court. I mean, not the court, while he was in prison and making phone calls. Alright, and don't forget to get me some coffees, you guys, or something on here, on this live stream. Alright, so that's one picture of the cell phone. Then we have this one. Hey, Cheryl, alright. Almost got that sheriff's badge. Right there's another picture of it. And I'm not sure what this is right here. It almost feels like that might be, perhaps something that Abby was wearing. Over here, I don't know, maybe the sweatshirt. I don't know. I think the sweatshirt was black. It's hard to tell what that is. But she must have been moved to reveal that. There was a shoe on top of that as well. Hey, look at that. Kelly Snyder, 20 months. All right. All right, now the main thing that we were going to go over, though, is this right here. What's the wow for, Cindy? I don't get it. Is there something wow-worthy in here? Hey, thanks, Cheryl. I don't even see who you're talking to. That person's name isn't even in here, Cindy. Let's see. Oh, it's 52 months. I see. I thought you were looking at something else. I can't even see. I had to put the, I forgot, if you're on top chat, everybody, switch it over to live chat. So yeah, look at that. 52 months by Laura. Man, hope this helps shut them up. Well, we'll see. We're going to go over here right now, but it's interesting that there's a cell phone there. There's other documents too. We can go over and see what they're saying, all right? So let's just get right to the main thing. All right, that's what we all have been waiting for. We don't need to see these other. There's a lot of motions out there from like NBC to get various clips, etc. All right, here we go. Now comes the state of Indiana by prosecuting attorney Nicholas McClelland. Respectfully objects to the defendant's motion to correct error and would ask the court to deny the same without a hearing. The defendant's motion does not warrant a motion to correct error because a motion for safekeeping filed by the Carroll County Sheriff's is not a critical stage of the proceedings, and the evidence concerning Brad Weber, Ron Logan, and Stacy Eldridge is not newly discovered evidence to warrant a new trial. The state would ask the court to consider the following. Hold on, let me get these. It's pretty long, actually. It's like a multi-pager. And thanks, Cheryl. Kelly Snyder, 20 months? Hell yes, she said. All right, so we got this one. Sandy Shirley. Kelly Snyder. Sandy Shirley, 23 months. She'll be a sheriff too. Then Kelly Snyder. Then we got Laura. Hope this shuts them down. I hope so too. All right, so here we go. Safekeeping order and 6th and 14th Amendment. A, that the defendant claims that his 6th and 14th Amendment were violated because he was deprived counsel at a safekeeping proceeding November 3rd, 2022, and that proceeding was a critical stage where he was entitled to an attorney. The defendant further claimed that since he did not have counsel at a hearing, the conviction should be overturned. And then it says, states that upon motion by a sheriff alleging that an inmate, so there's a, like say, that IC 353311-1 states that upon motion by the sheriff alleging that an inmate in a county jail awaiting trial is in danger of serious bodily injury or death or represents a substantial threat to the safety of others, the court shall determine whether the inmate is in imminent danger of serious bodily injury or death or represents a substantial threat to the safety of others. If the court finds that the inmate is in danger of serious bodily injury or death or represents a substantial threat to the safety of others, it shall order that the sheriff to transfer the inmate to another county jail or to a facility of the Department of Corrections. Well, it sounds like that's what they did. That the state does not says that the state does not require the court to have a hearing to make this determination. The court can make this determination based on the motion alone. That the defendant in this case was taken into custody on October 26, 2022, and housed at the Carroll County Jail. So maybe we get to hear actually how this went down now. Want me to take your face off the screen there? All right. And so that an initial hearing was held on October 28th. So that was 2 days after he was arrested, where the defendant entered a plea of not guilty. The court advised the defendant of his right to counsel, and the defendant notified the court that he would hire his own counsel. He at no time stated that he had counsel. See order herein. And remember, he wrote that little note that was just kind of, scribbled it out almost. I mean, it's just horrendous. It's almost as bad as my handwriting. But it was like he was saying stuff like, I don't have the money. I'm asking the court to provide me an attorney. And by the way, the notebooks that people have ordered, I've already got them all in envelopes and ready to ship. They're in a bag. I'm just doing this first, and then I'll bring them over to the post office to ship them off. But if you want one of the notebooks, the new notebook, GHI notebook, you can send, if you send 30 to PayPal, you get the notebook, stress ball, pen, a poker chip, and I'll send it all off. All right. So E is that an initial hearing was held on October 28, 2022, where the defendant entered a plea of not guilty. The court advised the defendant of his right of counsel, and the defendant notified the court that he would hire his own counsel. He at no time stated that he had counsel. See order herein. That after the initial hearing, the defendant was moved to White County Jail due to overcrowding at the Carroll County Jail. He was not moved to the White County Jail due to any safekeeping order. That on November 2nd, 2022, the Carroll County Sheriff Toby Lesenby filed a request by the Sheriff of Carroll County, Indiana, to transfer inmate from the custody of the Sheriff to the custody of the Indiana Department of Corrections for safekeeping, commonly referred to a motion of safekeeping herein attached as State Exhibit 2. H. That on November 3rd, 2022, the state received an email from attorney Brett Gibson stating that he would not be representing the defendant herein attached as State Exhibit 3. That on November 3rd, 2022, the court granted the sheriff motion without a hearing. So remember in that last document, they made it seem like he said he was representing Allen and he shouldn't have spoke. I guess it is the day after. So the day after that, I don't know. So on the 3rd, the state received an email from attorney Brett Gibson stating that he would not be representing the defendant. Then I is that on November 3rd, 2022, the court granted the sheriff motion without a hearing and determined that the defendant was in imminent danger of serious bodily injury or death or represents a substantial threat to the safety of others, not based on any facts or alleged acts by the defendant, but by the insistence of public information, noting that it is extremely dangerous, and I put all public servants in a dangerous situation, order herein attached as State Exhibit 4. So he's saying, let's see, but the insistence, hold on, let me read that part again. So it's not based on any facts or alleged acts by the defendant, but by the insistence on public information, noting that it is extremely dangerous, and I put all public servants in a dangerous situation, order herein attached. That in this order, the court further noted that the defendant intended on hiring private counsel, further supporting that no attorney had entered their appearance of counsel of record for the defendant. That a motion for safekeeping is not considered a critical stage of the proceedings where the defendant is required to be present with counsel. That the sheriff had standing to file the motion for safekeeping because although the defendant was moved to the White County Jail, he was a Carroll County defendant. He was only moved to the White County Jail because the Carroll County Jail did not have sufficient room to house him in a cell by himself, as evidenced by the affidavit of Toby Lesenby. So when he was originally just moved to a different jail, it wasn't because he wasn't safe. It was because that jail, the jail in Carroll County, was overpopulated. So he put it in, moved him to White County Jail where there was room. But then at that point, it became, safekeeping was in question. That Judge Diener was the presiding judge over the case at the time and therefore had jurisdiction over the case, and further was within that jurisdiction and within IC 353311-1 to make a ruling on the motion without a hearing. That as of the filing of the motion for safekeeping, the defendant did not have an attorney of record. And that same statute or whatever a code there, IC 353311-2, does allow the defendant to request a post-transfer hearing, which is what occurred in this case. The defendant requested a hearing on the safekeeping order, and one was held on June 15th, 2023. And that's quite a bit later, that's, when is that? That's about 6-7 months later. 7 months probably. That at the June 15th, 2023 hearing, the court found that the defense's allegations were untruthful and not well founded and denied the motion to modify the safekeeping order. The court further found that the safekeeping order was reasonable and necessary to ensure the defendant's safety and to prevent serious bodily injury to himself, thereby affirming the court's order on November 3rd, 2022. See order herein, attached, State Exhibit 6. Do we have that? Oh, that's missing from this. Hold on. Oh, this might be it right here. Let's see. The court, having had this matter under advisement following hearing and having considered the evidence and the arguments, defendant is currently incarcerated in Westville Correctional Facility under safekeeping order. The court order states that the court finds that defendant is an inmate awaiting trial and is in imminent danger of serious bodily injury. Yeah, so this is the court made the order, and there it is. That's the backup information there. I don't want to go through the whole thing, but all right. Which one was I at? See order. Oh, there it is. Okay. Therefore, the defendant had a right to object and exercise that right, and his counsel failed to show the court that the safekeeping order was unnecessary. In fact, the court found that the defense not only did not meet their burden, but that the evidence presented at the hearing did not support the allegations advanced by the defense counsel. See, that's what the defense does. They just kind of make up stuff based on a whim. Oh, look at that. Oh, it means this. And then I think the judge, when she tried to get remove these two attorneys, was doing Richard Allen a favor. But unfortunately, they were put back on because they weren't allowed a hearing that Judge Gohl didn't want to have to save them from embarrassment. Okay, and then R says that the defense filed, and they chose not to be in that hearing, that the defense filed an additional verified motion for immediate transfer of custody on September 18, 2023, which the court denied without a hearing, that the defendant's due process rights and constitutional rights were protected throughout the course of the case, that under both the Sixth Amendment of the United States Constitution and Article 1, Section 13 of the Indiana Constitution, the right to counsel only applies to critical stages of the prosecution. Isn't that crazy, all the stuff that you gotta keep in mind, little errors that you might make when you arrest somebody for killing somebody, and you have to worry about these little tiny technicalities all over the place. The right to counsel is not a generalized protection for all purposes. It is not a right that is implicated just because questions of law may arise. What happened? happened? I just like shot down a whole different page. Where was I? Safekeeping defendant did not have an attorney of record. I think we were like over here, right? Anybody remember what letter I was on? No, I can't do a rewind and play it. Motion for safekeeping does not touch on matters of guilt. Okay, I think it's up here. All right, right here. The motion for safekeeping does not touch on matters of guilt or impact the ability to have a fair trial. It is a mechanism for housing the defendant in a penal facility pending trial that will keep him and others safe. The defendant is not facing the advocacy of the prosecutor with respect to his guilt or innocence of the criminal charges. It further is not a stage where incrimination may occur or where the opportunity to present a defense to the charge must be seized or forever be lost or impaired. It has been found that the filing of information is not a critical stage. The probable cause hearing or initial hearing are not critical stages, nor is the procedure to select a special judge. It is safe to surmise that given those rulings, a motion that does not even require a hearing would not be a critical stage in the proceedings, which in turn would not entitle the defendant to a new trial. That since this was not a critical stage of the proceedings, the defendant did not have a Sixth Amendment right to counsel, so he was not denied the Sixth Amendment right to counsel. That even if this was determined to be a critical stage in the proceedings, any Sixth Amendment right to counsel would be reviewable under the harmless error analysis. All right, and it says that the defense cite United States versus Chronic as precedent to overturn the conviction, but they do so because they misunderstand the case. The defense, I don't think they misunderstand stuff, the defense. I think what they do is they just willfully try to sell something, just complete bullcrap, just like the cell phone data. There's information in the case that absolutely refutes things that they say, but they just don't want to listen to it. I mean, it's unbelievable, these guys. And by the way, if you're out there and you have the ability to help support the channel, allows me to keep doing these live streams like this. And at the end of the month, we're able to, oftentimes, I don't know about this month, but we give away funds to various true crime related charities, a scholarship fund. We also have a DNA fund that we put money into. So I could use your guys' help this month. We kind of started off woefully slow, so if you have the ability to, I would appreciate it. Thank you. The defense cites United States. Okay, so this is where they say the defense believes that the case says that harmless error analysis is precluded because the defendant was denied counsel at a critical stage. However, the case states that Sixth Amendment violations raise two questions: whether a Sixth Amendment violation has occurred and whether the constitutional violation was harmless. Prejudice must be an element of the Constitution violation to warrant reversal. In Chronic, the issue was ineffective assistance of counsel, not lack of representation at a critical stage. Yeah, I mean, that's totally different. Ineffective counsel, there wasn't, right? In determining if not having an attorney at a critical stage reaches the level of a violation, the harmless error analysis is used. That the lack of a hearing for the safekeeping motion on November 3rd, 2022, and the lack of counsel before the decision was made by the court had no effect on the jury verdict and therefore is harmless. The jury did not find the defendant guilty because a determination on his safekeeping was made without a hearing on November 3rd, 2022, and no attorney appeared. Hey, thanks, Mary C. Let's see. And it says, nor did not having an attorney or a hearing at this stage permanently deprive the defendant of the opportunity to raise any claims or assert any defense. Clearly, the defense did that after the order was entered. The lack of counsel must be complete to apply the presumption of prejudice. Wright versus Van Patten. The presumption of prejudice only applies when the error infects the entire trial process and necessarily renders it fundamentally unfair. The chronic exception is exceedingly narrow and is only applied in cases of non-representation throughout the entire case. Due process under the 14th Amendment as it pertains to Brad Weber testimony. Okay, here we go. Wow, it's your first one on a live stream, Mary C. Very cool. Thank you. Due process under the 14th Amendment as it pertains to Brad Weber. So here we are. We're now talking about Brad Weber. Not sure what's going on here with this. Let me turn off my phone. I don't know even how to turn off that. That the defense argues that the defendant's due process right under the 14th Amendment of the United States Constitution was violated because the state presented testimony that Brad Weber arrived home in a white van around 2:30 p.m., knowing that the testimony was false before it was elicited or failing to correct it once it had been elicited. The defense cites a video located in discovery from the evidence near the Monenhigh Bridge, a video that was included in the discovery turned over to the defense, and the defense had the entire time of trial. So the defense had that video, just like I said. A video that was included in the discovery turned over to the defense, and that the defense had the entire time of trial. That the exhibit presented by the defense is in the form of a YouTube link that is not identified as an item of evidence by an Indiana State Police number, and therefore is an improper submission for consideration by the court. It is unverified by legitimate means as to the date and the time. Defense alleged that the time in the video is off by 12 hours, without any proof of said allegation except their apparent ability to tell the time by simply looking at the daylight and moonlight in the video. I'm not sure where they said that. Hold on. I don't remember reading that part where I could do that. I'm the one that did the daylight and said, yeah, I mean, it's consistent with later in the day. But we don't know if it's 12 hours and 20 minutes off. We don't know if it's, that the exhibit, let me read that part again. That the exhibit presented by the defense is in the form of a YouTube link that is not identified as an item of evidence by an Indiana State Police number, and therefore is an improper submission for consideration by the court. It is unverified by legitimate means as to the date and time. Let's see. Was included in the discovery. Well, see, but up here it says that the video was included in discovery, turned over to the defense, and that the defense had the entire time. And then here it sounds like defense alleged that the time in the video is off by 12 hours, but then they're also saying that the video that they gave the defense is, it's improper, you can't really use it in court, but here you go, something like that. It is unverified by legitimate means as to date and time. Defense alleged that the time in the video is off by 12 hours without any proof of said allegations except their apparent ability to tell the time by simply looking at the daylight and moonlight in the video. Does anybody remember them saying that in that document? They further make assumptions about the content of the video. They present zero evidence to support said allegations. That the simple answer is that a motion to correct error only applies to newly discovered evidence. From the defense's own admission, this is not newly discovered evidence, but rather evidence that they had been provided long before trial. The defense chose not to present it at trial as part of their trial strategy. Exactly. That's what I was telling you guys. It ruins their timeline. They wanted the jury to believe that possibly Brad Weber, when he was driving by, that somebody, that the girl somehow ended up in his van. They were trying to imply that quietly. Yeah, he went in with Brad Weber. He was, they were in a van. They were in a vehicle and they went somewhere. Then it turns out, well, shit, now he's driving by at 2:44, so heck, that doesn't really line up with them coming down the other end of the bridge. Let's leave that out for now. Hey, maybe we can bring it up later after trial and use it for something. That simple answer is that the motion to correct error only applies to newly discovered evidence. From the defense's own admission, this is not newly discovered evidence, but rather evidence that they were provided with long before trial. The defense chose not to present it at trial as part of their trial strategy. It was a trial strategy by experienced defense trial attorneys. Therefore, it is a moot issue because it's not newly discovered evidence. I think it also just means that, the prosecution could have chosen a multiple, but they, the thing is it's only 20 minutes later, so the video of Brad Weber driving by still shows that Richard Allen saw the van while it was driving by. He just likely saw it from the crime scene, which is a much better vantage point to see it. But the prosecution went with the theory, it matched what Richard Allen said. There was this 18 to 25 minute, or 218 to 225, the phone stopped moving, and then it started moving again, and they used that time, the 225 frame, when the van drove by. It's a good theory. It matches his. Now, why the defense didn't use the new video to show that, wow, Richard Allen, when he confesses, some of it, the information is inaccurate. They didn't use that because 244 still puts the van at the crime scene, and then it starts admitting to the fact that the van was there at that time. They were trying to say he wasn't even there. He was doing stuff with his ATM machines, etc., etc. They used that technique. They were hoping the jury would go, wow, yeah, he wasn't even there. But nope, he was actually there just 20 minutes after, later than previously thought. The defense chose not to present it at trial as part of their trial strategy. It was a trial strategy by experienced defense attorneys. Therefore, it is a moot issue because it is not newly discovered evidence. That, at best, this is impeachable evidence that the defense could have used when Brad Weber was on the stand testifying. Exactly. Evidence which is merely impeaching is not available as grounds for a new trial under the rules concerning newly discovered evidence. Bell versus State. Further evidence must be more than impeachable or cumulative, must not be reasonable, discoverable before trial, and also evidence that would probably result in a different verdict. Yeah, I think you could have easily just said, oh yeah, he saw the girls at the crime scene. He probably intentionally wanted to assault them below, but then he, saw that it was kind of open down there, and then he took him across the creek, and that's where the assault took place. He had him disrobed, the phone was on the ground, never moved again, and then he was in the process of doing whatever he was doing, and then about 13 minutes later, Weber's van drives by, he panics, kills Libby. Abby's just frozen, really scared, and he was going to let her live, let her redress again, put her shoes back on. She was, really scared, and then he changed his mind again. Out of selfishness, he killed her after he allowed her to redress, put her shoes back on, etc. And you know that she was alive when she dressed because her hands are tucked into the sweatshirt, gripping the end of the sweatshirt, for anybody who's seen the crime scene photos. And law enforcement also believes she was alive while she was dressed. And all of the blood, for example, was below her neck area on the ground. It wasn't on the clothing. All right. Finally, the testimony by Brad Weber was not the exclusive evidence the state used to convict Richard Allen. Brad Weber was put on the stand multiple times, and the defense had every opportunity to cross-examine him. If anything, this evidence is no more than impeachment evidence that the defense chose not to use. The defense is not permitted to request a new trial to change strategy when their chosen path fails. I mean, that's such a perfect way to write that. This also applies to any phone pings that were in discovery for Brad Weber. This is not newly discovered evidence by the defense's own admissions. Further, at best, it is impeachable, because remember now it says, his phone pinged by, I think it was FBI data, at 250, which matches the 244 time when it's driving by, but they decided not to use it. Further, at best, it is impeachable evidence that the defense chose not to use at trial. Richie Davis claims of confession by Ron Logan. Hey, thanks, Lynette Eades. Reese Davis. So this is let's see how close it is to stuff that I was saying. So far it's really close. I said almost exactly the same stuff we just heard. And this is just by using common sense and logic. I don't have a law degree or anything like that. It seems like those people get hindered in the way that they think. Oh, Richard Allen's innocent, you guys. We're all Richard Allen. Although that guy's not an attorney. Richie Davis, or Ricky Davis, claim of confession by Ron Logan. Okay, this is what I've said already, that it's double hearsay, and that the person who wrote down what Ricky said that Ron Logan said, he also didn't even pass that lie detector test that it was in. Okay? All right, so that the defense next argue that Ricky Davis claimed that Ron Logan made a confession to him, said claim being newly discovered evidence entitling the defendant to a new trial, that any information pertaining to Ron Logan falls under the state's motion in limine concerning third-party motive. The defense had 3 days, and we talked about this too, they could find no nexus. The defense had 3 days to present evidence to meet their burden for third-party motive. They mentioned Ron Logan, but failed to meet their burden with the court. They chose not to present this evidence in that hearing, because it's double hearsay. All right? They also did not present this evidence when they renewed their motion during the trial. This now seems to be an effort by the defense to use a motion to correct error in an effort to, you know what they're trying to do? Correct their own errors. They're trying to correct their own errors in judgment on what strategy to use. Right? This now seems to be an error by the defense to use a motion to correct error in an effort to circumvent their burden concerning third-party motive. That this evidence, along with the video surveillance evidence from residents, was received by the defense on January 30th, 2024, as evidenced by the discovery release herein attached as State Exhibit 7. That the defense team, consisting of 3 experienced defense trial attorneys, made a choice not to fully explore or present the Ricky Davis claim, which the defense admits was contained in discovery. So they gave it to him. So here you go, you guys. The prosecution gave him these little nuggets that they could use, you know. They probably didn't want to give it to him because it's just garbage, right? But they had it. They could have used it. They didn't do it. That the alleged confession was made to an inmate at the Department of Corrections named Ricky Davis, who was serving 50 years for dealing in methamphetamine. That law enforcement interviewed Ricky Davis and submitted him to a polygraph at his request. That Mr. Davis failed the there we go, like it, failed the polygraph test miserably. That Mr. Davis gave a statement that alleged Ron Logan confessed to him that he killed the older girl first and then took the younger one away from the scene. That he killed the second victim later and then brought her back to the scene. I don't remember reading that in that document. That he killed the second victim later and then brought her back to the scene, and he went back to the scene after search parties searched his property and moved the girls to another location, that he removed the cell phone battery from the girl's phone and left the phone behind, and that he took the girl's clothing from the scene and burned. Many of these details are directly I don't think I read it. I don't remember reading any of that stuff. Do you guys remember that at all? Any of that stuff? Remember the rabbits and horses? Let's see. Later, and then brought her back to the scene after, and that he went to the scene after. Maybe we're missing some stuff from those confessions. Yeah, it's not related, Moon. We're talking about something totally different. Let's see. Victim later, and then brought her back to the scene. That he went back to the scene after search parties searched the property and moved the girls to another location. That he removed the cell phone battery from the girl's phone and left the phone behind, and that he took the girl's clothing from the scene and burned. Took the girl's clothing from the scene and burned it. Well, their clothing was right there. Many of these details are directly contradicted by the evidence. The others have no evidentiary support. And what I was saying was that, Abby's on the bridge. People that watched the trial, everybody that saw it, they were both nervous on the bridge, Abby and Libby. Abby was even like, "Don't leave me up here." And then she says, "Is that a gun? He's got a gun." And then you're going to tell me a few moments later when Ron Logan said, "Hey, do you want to look at my bunnies and horses?" She goes, "Yay, let's go look at them." I mean, that's garbage, you guys. Absolute garbage. And yet, the people at the pro-Richard Allen wackos, they think that stuff sounds legit to them. It's unbelievable. Yeah, I read the 2 to 3 page handwritten. I don't remember reading a lot of that stuff, though. We went over it many times. I don't remember reading that he took left the crime scene and then came back much later. I don't remember reading that at all. All right, so then it says that even the alleged information from Ron Logan about the box cutter, that would not have been enough to establish probable cause to arrest Ron Logan. No evidence places him at the scene of the murders. Unlike the defendant, who left an unspent round at the scene that was subsequently matched to a gun that he owned, that he himself asserted was never in anyone else's possession, who put himself on the bridge at the time of the abduction and wore the same clothing as bridge guy. Right. That's what I keep trying to tell people. It's like, who else is it if it's not Richard Allen? Because nobody else is even around. Nobody else has proven to be there. Nothing. Well, what about Ron Logan's pings? Right. His phone that pinged in the area is consistent with. I mean, my God, his house is right there. They were found on his property, for God's sakes. It doesn't mean he was there because his phone pinged on the property. There's only one cell tower. You can't triangulate with it. Let me just read that one again. That even with the alleged information from Ron Logan about the box cutter, there would not have been enough to establish probable cause to arrest Ron Logan. No evidence places him at the scene of the murders, unlike the defendant. And then Stacy Eldridge, expert opinion, that the defense finally alleges that an affidavit by Stacy Eldridge supports that dirt or water did not cause the damage in the auxiliary jack in order to log wired headphones were plugged in and unplugged. They allege that this newly discovered evidence that would probably produce a different result at a new trial. Hey, thanks, Jim Lawn. What the hell is a gigawatt? That Stacy Eldridge testified at trial for the defense that she did not submit any report, log, or any other information that supported her position that the log accurately supports that headphones were plugged into and later unplugged from the auxiliary jack. That this opinion was only supported by her testimony at trial. that prior to her testimony, Stacy Eldridge had only done one other forensic phone analysis and had only testified one time prior about a forensic phone analysis. That Stacy Eldridge only gained the education to be able to testify to forensic phone analysis as recently as 2023. That the bulk of her expertise is in computer and network forensics, not cell phone forensics. See her CV attached. That the state called, so basically all the other documents in here are the supporting documents of this motion here. So it's got like a few different exhibits in here. Let's see. That prior to her testimony, Stacy Eldridge had only done one other forensic. That Stacy Eldridge only gained. Okay, I think we're on G here. That the state called Sergeant Christopher Cecil on rebuttal to testify about headphones and auxiliary jack of the phone. That Sergeant Cecil was able to observe photos of the phone when it was found, herein attached as State Exhibit 9, 10, 11. That Sergeant Christopher Cecil did testify that one plausible explanation for the log entry is that there was dirt or water in the jack that caused a malfunction. And it's actually not really a malfunction. I would just say that it even says from the Apple site that if you get a little water, especially water that has minerals in it, it'll just make a electrical connection as if a jack was plugged in. And then once it evaporates or leaves, then that connection is gone. It looks like it's been unplugged, the jack. So it's not really a malfunction. It's functioning correctly. It's just that it thinks that something's plugged in because the water created a connection. Let's see. Did we get any coffees today? Not one. Not one damn coffee. Come on, you guys. You can do it. Rebuttal to testify that Sergeant Cecil was able to observe photos of the phone when it was found herein attached to State Exhibit 9, 10, and 11. So I have all those. Let's see. Here's 9. Look at you guys. I mean, hello. You see that? There's even like water on there. It's almost like dew in the morning. See that? It's wet, and right there, I mean, hell, look right even here, you can see, look at, there's dirt on it. I mean, give me a break. There's another picture, dirt. And there's another one. All right. But hey, you guys, if you do the buy me a coffee in that link right there, I would appreciate it. It takes less percentage than the YouTube, and you know, it helps support the channel, you guys. That Sergeant Cecil was able to observe photos of the phone when it was found herein attached as State Exhibits 9, 10, 11. That Sergeant Christopher Cecil did testify that one plausible explanation for the log entry is that there was dirt or water in the jack that caused a malfunction. This is in part based on the condition that the phone was found in, how long it was outside before it was found, and his knowledge and experience as a forensic phone examiner. That this also based, hey, thanks Alex, appreciate it. That this also based on the facts found through the investigation, including that the phone did not move after 2:32 p.m. on February 13th. That there were no headphones found. Yeah, see, that's what we always try to tell people. The phone never moved again after 2:32. So for somebody to plug a jack into the phone, they would have had to be like, you know, like the game Operation, where you're just kind of underneath there in the dark, hoping that God you plug it into a cell phone jack. I mean, give me a break. The logic used by the pro Richard Allen people And I don't mean to, offend you guys, but come on, be better. Be better with your brains. That this is also based on the facts that found through the investigation, including that the phone did not move after 2:32 on February 13th, and that there were no headphones found with the bodies. That it is unlikely that someone returned to the crime scene after 2:32, removed the phone from underneath the body of Abby, plugged headphones into the phone, and then kept those headphones in for 5 hours, unplugged them, and then put the phone back underneath the body, all while not moving the phone. That is, didn't I sell you guys all this? That's almost like your exact thing that I said. I mean, that is so perfect. It's almost sarcastic. Let's do that one again. That this is also based on the facts found. So how does any of the pro Richard Allen... Oh, I know what it is. We got to listen to Andrew Baldwin's amazing ideas. That the killer had a Faraday bag down there. Put the phone in that. Oh, it could have also been put inside a refrigerator. Don't forget that part. Jesus, these guys, I tell you. That this is also based on the facts found through the investigation, including that the phone did not move after 2:32 p.m. on February 13, 2017. And there were no headphones found with the bodies. That it is unlikely that someone returned to the crime scene after 2:32, removed the phone from underneath the body of Abby, plugged the headphones into the phone, and then kept those headphones in for 5 hours, unplugged them, and then put the phone back underneath the body, all while magically not moving the phone at all. That the defense expert, Stacy Eldridge, sat in the courtroom during Sergeant Cecil's testimony, and the defense had an opportunity to recall her as a witness to rebut Sergeant Cecil's testimony, but chose not to. That there is nothing in the logs, reports, or extractions that would indicate whether or not the phone had some kind of water damage, because that kind of damage is not registered in logs, reports, or extractions of the phone. Whether or not there was water damage can only be determined by physically examining the phone, which Stacy Eldridge did not do. That again, at best, this is impeachment evidence that could have been brought out in testimony during trial in an effort to impeach Sergeant Cecil's testimony. This is not newly discovered evidence to warrant overturning the conviction. But they got that like after their expert, the defense, said, hey, it was plugged in and then it was unplugged. They actually searched on Google at a break and then said, oh yeah. And then they came back, the prosecution did, with the images and then, said, because it's true. I mean, look it up. They didn't bring an expert on or anything, but it shows you that, okay, yeah, I mean, that's... The same let's see, that again, at best, this is impeachment evidence that could have been brought out in testimony during trial in an effort to impeach Sergeant Cecil's testimony. This is not newly discovered evidence to warrant overturning the conviction. The same analysis that was used in the above evidence concerning Brad Weber and Ron Logan would apply to this evidence as well. It is not newly discovered evidence, but is impeachment evidence, and therefore cannot be the basis for a motion to correct error. Wherefore, the state of Indiana, by prosecuting attorney Nicholas C. McClellan, respectfully requests this court deny the motion to correct error without a hearing and for all other just and proper relief in the premises. I mean, man, he just destroyed that entire thing that they put out. Now, if you're listening to any of the defense attorneys and they try to pretend that this didn't do that, they're full of crap, okay? Just go listen to what they say, and then I guarantee you they are going to go, oh, that's bull crap, man. They should have done this and that, blah, 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 blah. It's garbage. Nick's response about the phantom representation is just so telling about the lack of credibility. Right. The whole document just shows you And I was even telling you guys the same stuff when we went over the defense's motion, to correct errors. When we read through it, it was just garbage. You just look at it. I mean, I'm surprised he didn't also bring up that it was double hearsay as well, and he didn't pass the polygraph test. He did mention that part. But also, the part about the time that Brad Weber actually drove by, it still places him there during the time the crime was being committed. So, the phone never moved again after 2:32. But, the crime was still taking place during that time on the other side of the creek. And I think it actually, ironically, I've always thought that is how it was. But at trial, I was like, okay, we'll go with that the van drove by at 2:25. He was freaked out, but killing them at 2:32 doesn't really make a lot of sense, does it? I mean, you kill them at 2:32, then how do you bring up a Sarah Carbaugh? I mean, what was Richard Allen doing there for the next hour and plus? So to me, it makes more sense that, like I put out in the video recently, that I have it right here on the screen. So right at the end of the bridge here, it was 2:14 and 34 seconds, and then the girls they're made to go down the hill, so they likely get down here by 2:17 or 2:18, and that's when the phone stopped moving. So maybe right down here is where he was going to assault them. Because remember, at 2:18, that's only 3.5 minutes later, so I could see going down the hill, and they make it to here, and the phone stopped moving from 2:18 to 2:25. So that's 7 minutes. So maybe he was down here with them. Maybe he even tried to walk under the bridge or somewhere over here. And then he realized, man, you can just see too well. So then he takes the girls over here, and maybe that accounts for the 60 or so meters that are missing. And then he brings them over here, and it's I would say from 2:25 to here, it makes sense that it would take maybe 7 minutes. So they walk over there, get over here, and then getting across the creek was a little slower. And then they go up 2:31. It goes up 2 flights. So if it was over 10 feet, maybe it registers as 2. And then the phone stops right here, and that's 2:32. And then there are like 13 or 14 minutes after that where Richard Allen is having them completely disrobe, maybe even throws in some of the clothing over here into the water. And then Weber's van drives by, and that's when Richard Allen panicked. And Libby was, kind of combative. She wasn't allowing Richard Allen to do whatever he wanted to do. And so he killed her out of anger. And she was a struggle. That's why her wounds are so bad. And then Abby's over there, probably really scared and, timid and crying, like scared. And she's nude. And he changes his mind. He goes, I'm going to let her live. And then she redresses herself, because her shoes would have had to have been off to take the skinny jeans off, right? Everybody knows that. So the skinny jeans she had on, she would have had to have her shoes off to take the skinny jeans off. So that means she was completely nude at one point, other than maybe the pink top that she had on, and maybe even the bras underneath it. Then she was allowed to dress herself, so she put which was still on the shore, was Libby's pants and Libby's sweatshirt, and her own shoes, I guess. So then she put the sweatshirt on, the pants, and then she put her shoes back on at that point. And the only reason he would let her put her shoes back on is because he was going to let her live. And then I think he changed his mind. After she was dressed, he realized that he has that public job. She's seen his face now. She will recognize him. And then that's where out of selfishness that we hear in his confession, that's when he killed Abby right there on the ground. And it just so happens it's on top of the shoe and on top of the phone that we just saw a minute ago. And then he went on to live his life. And he said he killed her out of selfishness to like preserve himself. And I think the killing of Libby, he didn't think that way. But he consciously had to think when it was with Abby after he allowed her to dress. He kind of said, okay, I'm going to let her live. But then he changed his mind. So he always remembers the fact that he changed his mind on that. And that's when he realized he's selfish and he killed her to preserve himself. All right, that's my theory on how that went. Yeah, I can read the questions better if you put them in super chats. That's what they're for. I can't. There's so many questions up there. I don't have time to. Yeah, he said he was selfish in his confession. He said that he was selfish. He killed them, and he also said that he killed them. He didn't want them to suffer. Okay, but I think again, that's how he killed Abby, because Abby has like one sort of puncture wound, pretty much dressed. I think all of the statements he's making is how he was feeling with her, but Libby, it wasn't that way. Hers was way more brutal, and I think he had some remorse for Abby. He felt bad for her, you know, and then he ends up killing her anyways. And that's why he sort of, I believe he sort of withered away over the years, because he was it just was eating away at his soul. That's why he wanted to, if you look at him, he looks totally different over the years. And I think he wanted to unburden himself by confessing to his family members. You know, he told his, I did it. And again, I've said this before, but he wanted to know if his family would still love him. He wanted to know that they would still love him even if they knew that he had done the crime. And his mother finally said something like that. But for a long time, they would say, yeah, but you didn't do it. And then he said, well, I think I did it. Because then he's trying to sort of back out of it a little bit. Because now he realizes they're not going to accept it, so then he tries to back out. It's not that he doesn't know that he did it. He was really like, I did it. I want you to know that I did it. No, you didn't. Yes, I did. I did do it. I mean, I think that when the jury's hearing all of that, I think it's almost ludicrous for people to believe he was confessing purely out of, like he was crazy. Okay? That's just people wanting to believe in that kind of stuff. It's garbage. This case is so, it's so obvious. I mean, I don't know how else to say it. Richard Allen is bridge guy. You know, we've gone over that 1,000 times. So there's no chance that he's not bridge guy. Now, when I say no chance, there's no reasonable chance that he is not. You know, so you got to look at it like, when he's right here. Hey, thanks, Stephanie. Oh, hold on. We also had Alex and CMAP. Thank you. On the coffees. And if you have a question, you can put it in your coffees too. You know, we can read those. But look, if you're just watching and you're not really familiar, just pay attention for a couple minutes and you'll probably feel differently here. I just want to show you this. Okay, I'm going to describe this again for the people who haven't seen it and you're still confused about the timeline. Is really everything in this case. I'm not going to use the animation here. I'm just going to do it right here. It shows you exactly why Richard Allen has to be bridge guy. And that's exactly what the defense team used. All right, not the defense team. The defense team, Jesus. That's exactly what the jury used. They didn't even use the bullet. They didn't use Sarah Carbaugh because he's bridge guy before all of that. So watch this. Let's just start. There's one couple things I want to bring up first. The 4 girls were over at the bridge at 12. Oh yeah, it's 12:25. I actually did have that in there, so I was wrong when I said 12. So at 12:25, the girls are at the bridge. Those 4 girls. Then they walk all the way over here, and then at 12:43, they take a picture at the bridge. Then they walk this way, and at 1:26, they're right here at a bench. Probably this bench right here. They're at this bench. And they didn't see Richard Allen that whole time. So his secondary story that he told, that he got there at 12 and left at 1:30, is completely bogus. All right, then at 1:26, they're leaving, and on the way out, and then 1 minute after they took that picture at the bench, a vehicle driving by the Hoosier Harvest Store matches Richard Allen's black Ford Focus and drives over here, probably parks at 128, 129, gets out of the vehicle. These girls are walking this direction, and then right here, Richard Allen, after walking on this trail right here, came onto the Freedom Bridge and then passes them right here, right where the woods start. And they all saw him, those 3 girls, and they saw him, and he verifies that. So everybody out there with a rational mind knows that Richard Allen is the person that these 3 girls saw, and that Richard Allen got there at 1:30, not 12 like he tried to sell before, because those 3 girls apparently never came forward that he wants to claim that he saw at that time. So anyways, Richard Allen gets on the trails, and he's right here at about 1:33. Now, walking quickly, it takes 11 minutes to walk from here all the way to the bridge here. So that would put him on the bridge at 1:44. All right, so that's 1:44. And then 3 minutes after that, right when he would arrive at the bridge, Betsy Blair drives by the Hoosier Harvest Store and parks. Probably gets out 1:48. Takes 6 minutes to get to the bridge. And so she gets down here, and then you realize that it takes 6 minutes. So if Richard Allen was here at 1:44, it'd take him to 1:50 to be running back this way to get past Betsy Blair to be over here somewhere. But, he didn't say he ran or sprinted somewhere, and why would he do that? That doesn't make any sense. So Betsy Blair gets there, 1:47, 1:48, starts walking, and she's walking quickly. And then as she's walking down the trail, Abby and Libby are dropped off. That's a technical fact. Libby, Kelsey's vehicle drives by the Hoosier Harvest Store at 1:49. Betsy Blair came in here at 1:46 right here. So it wasn't 1:47. It was 1:46, drove by the Hoosier Harvest Store, parked, got out 1:47. And that means, she would see Richard Allen on the trail if he was passing her. Do you guys get it? So just think about that. And then as Betsy Blair is just starting to walk down the trail, because this is one of her loops, she always would park here, go to the bridge, come up here, go down this trail a little bit partially, then back up, then to the Freedom Bridge over here, and then back to her car and leave. That would be one of her loops. So here it is at... this is the parking area. So at 1:46, I don't know why my phone's just blowing up every 2 seconds. I can't get it to stop. I can't turn off the sound. I don't know how to do it. I've already got the volume off. It just keeps buzzing and buzzing and buzzing. So 1:46, Betsy Blair drives by right here. Gets out, 1:47, starts walking. Then 1:49, Kelsey drives by here. That means they dropped the girls off, or she dropped the girls off maybe a minute before after Betsy Blair started walking down the trail. So Betsy Blair's probably like right here. The girls are dropped off. Betsy Blair, but she's exercising, right? So she's moving quick. And then she makes it to the barricade she set at trial, and then she turned around. Barricade is 111 feet from platform 1, not 50 feet like she kind of remembered. All right, so when she turned around, she started walking back this way. Again, she's walking quicker because she's exercising, and then she passes Abby and Libby, who are right behind her. We're behind her, but they're just kind of whimsically walking down the trail, taking pictures, etc., making their way to the bridge. And she passes Abby and Libby. And in the paper, at trial, she said she she thought it was them, and then when she saw them on the news, she knew it was them. But people still kind of try to make it so it's not really them that she saw, but it has to be. She was right behind them. Right behind her, I mean. And then Betsy Blair passes, keeps walking this way, and then Abby and Libby therefore have to run into the guy that was on platform 1. But when Betsy Blair got right here, she saw the man standing on platform 1. That's exactly where Richard Allen said he was standing. In his interview with police, he said he went to the first platform and he was standing there looking at fish. Okay, when Betsy Blair got there, she looks over and there's the guy standing on platform 1. So she turns around, passes Abby and Libby, and right after that, Abby and Libby are walking this way, and then around 2:01, they make their way to the start of the bridge, and Richard Allen's still in the area. Now, did he pass them really quick, say, hey, and then walk back here and watch what they were doing, and then from this position, you can then see if anybody's coming down the trail, but he had been there right here for about 7 or 8 minutes, maybe 9 minutes at this point, and could see that there was nobody on this side of the bridge or anything. Okay, so he knew there was nobody past Abby and Libby, so he waited and watched, just like he said. He lied in wait. And then he saw the girls cross the bridge, and then when they're probably over in this area, he starts hustling across. Then the girls go across over here. Libby gets off the end of the bridge first. She's standing off the end of the bridge. And then when, and Abby's still on the bridge, and when the bridge guy, Richard Allen, starts getting closer, probably around in this area, she turns her phone on and records Abby, basically. And the bridge guy's kind of like behind her, and then eventually there's 2 seconds where they were able to stabilize, and you get the image of bridge guy where he's about right here, 60 feet away from the end of the bridge. And, that's when he's like, he walks by, says, hey, Abby's saying, don't leave me up here. Before that, don't leave me up here. Then he comes by and says, hey, guys. And then Libby says, hey. And then Abby says, he's got a gun, he's got a gun. And then down the hill. Right? And then the rest is over there. But see how it can't be anybody else? There's nobody else out there. You'd have to believe that over in this spot right here, so Richard Allen did get there, and he was standing there at 1:44, and then all of a sudden he goes, I don't want to look at fish anymore, and he walked over here. Then another leprechaun of some sort came running out of the woods and stood on platform 1 too, wearing exactly the same clothing that he was wearing. Well, Richard Allen is over here. Then when the girls came by, they went across with that person. But then Richard Allen flew up in the air and got back to his car because he never passed Betsy Blair again. You know what I'm saying? So the logic that people deploy, that they're willfully ignorant for content. So they want to be able to have as much content as possible, so they're willfully ignorant. Once you realize that bridge guy is Richard Allen, that's it. There isn't any, if you can prove that there was somebody else there, and if Richard Allen comes forward someday and says, hey, guess what? There was somebody else I was with. Okay, that's great and everything. Hey, thanks, K-Me. And also thank you to Stephanie for the coffee. Appreciate it. Right, so if anybody out that just saw what I just saw, can you come up with something that refutes what I just showed you? And I won't be angry. I just want you to say it so I can see what you're saying. Hey, thanks, Dickie D. Your coverage on this case is absolutely brilliant. You're so smart and all that. Well, thank you. Some people think that. Some people don't like me at all, but I try to do all the cases the same. Some of them aren't as popular, so people don't watch me on those. You guys should watch I'm about to put out a video on the surveillance footage that was just released in the Cypress 3 case that I call it. The Cypress 3, where a mother, her son, their adult son, and the son's girlfriend were all killed on the second floor of their house in Cypress, Texas. In a 6-minute window, they were all shot. By a person that was previously kind of, there was a vehicle moving around the neighborhood, and actually fixed an error that I made in my analysis earlier. You'll see it during it, because I thought there was that other cul-de-sac where the vehicle drove down, and that is the cul-de-sac that's in the surveillance footage, not the... It's so similar looking, though, to the cul-de-sac where the crime took place. Really bizarre, but the timing all worked with that surveillance footage. Hey, thanks, Meatball Burner Phone. What if someone was down the hill waiting, Gray? Well, Richard Allen's still there, though, CK. So it doesn't matter if there was somebody down the hill waiting. You know, if you want to say that Ron Logan was down here, okay, great. Richard Allen brought the girls to Ron Logan, okay, because he's the one that said, "Guys, down the hill." Richard Allen did, right? So he's the one that took the girls down the hill there, right? So he's already toast for abduction. Like he's the one that would have abducted the girls, taken them down the hill, and then across the creek. What are the question marks there for Christopher Owens? Nobody knows what that means. Yeah, it's still felony murder. It's there's no change in it. Well, then don't type in stupid stuff, CK. I mean, if you're just doing it for a joke, then you're, you know, I don't get it, man. People actually say that stuff. What if there was somebody down the hill? That's absolutely what they say all the time. So it's not funny, because that's exactly what people say. And I was just answering your stupid question and trying to do it in a kind way, but instead you come back with nonsense. The only way Richard Allen is not bridge guy is if he was walking through the forest, not the path, so he didn't see the girls. Well, he did, because he said he saw the girls, remember? The other three girls, so he was walking on the path. We already know that. Yeah. We already know that he walked all the way down the path, and he was standing on the bridge. So you'd have to think that he took off after the time that Betsy Blair... I mean, you would have to say that between the time, in a 4-minute window, because Betsy Blair could see anybody that was on the bridge from right here. So when she got there at 1:47 or so, at 1:50, that's 6 minutes after Richard Allen got to the bridge, he had already gone into the woods, and another leprechaun replaced themselves in the same spot. Does that make any sense to anybody? And then nobody on the trails saw either of those two leprechauns again. Well, it wasn't, because Betsy Blair said it was a taller guy with poofy brown hair. Betsy Blair was 111 feet away. Poofy brown hair matches the brown hat that he was wearing. She just doesn't remember clearly. Okay, now that's so common. Guess what? The 4 girls over here, out of the 3 witnesses, they all saw one person. Does everybody agree with that? That there wasn't 3 people in a row walking by. They all saw one. They all say they only saw one person. But all of their descriptions are a bit different. Hey, thanks, Broyne. All of their descriptions are a bit different. Some say he was wearing all black. The other said all blue. The other one said dark blue jacket, dark blue pants, or something like that. You know, they're all 3 different, but they all saw the same person. And then when they saw the picture of the bridge guy, they go, oh yeah, that's the guy we saw. Because that was an actual visual remembrance instead of just trying to use their mind. Okay? Mm-hmm. See, maybe that would be more funny there, CK, but your first one wasn't. It didn't have any humor value to it, because that's exactly what people literally say daily. I still want to know, did he walk in front of the harvester? No, he didn't. And nobody knows how he got back to the vehicle. You know, we think he went through the cemetery, and that's how you use Sarah Carbaugh, but I don't really care about Sarah Carbaugh's testimony. It could be true, it might not be. You don't know. What is true about what Sarah Carbaugh said was when she was driving this way at 3:57, she saw a group of people standing here. So that part of the story is validated. And so then you go, well, you know, what, did she just make up that part of the story when she saw the muddy and bloody guy? And then also the flannel shirt guy, McCain, he said when he walked to his car, there was a bunch of people here too. And that was after 4, so that all matches. No, in front. Yeah. I think I figured that out. And no, that's not a beer. It's diet caffeine-free Coke. Tastes the same. I don't know what that means. Gen Exodus. Nobody cares. Let's see. Hi, what happened? There's just you'll have to go back and watch it. We just did an entire show on the there's tons of documents that came out. There's also, like, NBC News here is trying to get access to some of these files. I thought it was interesting. There was one here that said, let me try to find the one I was looking at. Okay, Nick said, at this point, I do not believe I will be hired. This is to Nick, a guy named, this is that letter. Brett said he doesn't think he's going to be hired. So that was the letter proving that Richard Allen had that attorney, but he wasn't really representing Allen at the time. Let's see. And I know there was one document that I was reading. I just saw a part of it. I am duly elected. The affirmation mentioned Richard Allen. Oh, that's the transfer order. The original one. November 3rd. Okay, let's see. Let's read this one. Right. On November 2nd, 2022, Toby Lesenby, Sheriff, Carroll County. Okay, this is that same document. As far as public desire to learn about access to court records, and this is where it's talking about that it's dangerous for Richard Allen. Okay, that's also Toby Lesenby. Okay, now this part here is what I was looking at here. What is this thing? Nicholas McClellan, Shane Evans. The following is a list of the items in this physical discovery release. 1 Seagate. So it says Allen Physical Discovery Release. So does that mean they're releasing this information? I don't know. I don't know what this means. This might be when they released. It's evidence that they gave Richard Allen, his attorneys, the footage of the car driving by and other information, the van driving by. I think that might be what this. What's the date of this? No, this is today. Well, 2/4. What's the date here? Or yesterday? Let's see. Allen jail calls. Inmate phone calls made by Allen while at Carroll County. So what's going on? Is this what they're going to release to the public here? The following is a list of items in the physical discovery release. On Seagate 3.5 inch, 2 terabyte SATA hard drive, labeled 02D2 Allen containing Allen jail calls. Inmate phone calls made by Allen while at Carroll County Jail. I mean, I'd love to have these. Thank you, death. Bye, chocolate. All Westville phone calls to 12/1/23. Inmate text or email data related to Allen at GTL. Account payment information. Evidence. Blair's Fitbit. Geofences. Neighborhood Canvas. Neighborhood Canvas 2019. Filing cabinet scans. Scanned electronic digital copies of filing cabinet paper documents and any data in those files. The files were uploaded and current to this date. Holder 2016 ceremony. Actual video from the Facebook feed of Odinist ceremony. So that's 2016 ceremony. So I guess there was a Facebook feed Interviews. Sandra Harrison interview and phone extraction by FBI in San Diego, California. File was too large for successful upload to eDiscovery. Photographs. Crime scene. They're not going to release any of this stuff. Crime scene autopsy and other follow-up photos. Some photograph files were too large for successful eDiscovery upload. 3D rendering. Wonder what that was. Commander State Police photos of crime scene autopsy and other investigative follow-up. German crime scene photographs. So it's Liberty German. ISP photos 12/7/2022. State police photos of crime scene and other investigative follow-up by CSI technician. Item 101422 SLM. Photos of Allen's water bottle in interview room submitted for evidence. FBI trail cameras. Trail camera photographs taken of crime scene. Why would you need a trail camera picture? I don't know what that means. FBI trail camera photographs taken from crime scene. J. Kramer photos. FBI crime scene photographs taken by S.A. Julia Kramer. Police and coroner reports. Nicholas McLean Drive. Reports are attached on separate hard drive listed below. So I wonder if they'll release some of this stuff then. All search warrants and court-related documents. Some files were too large for successful discovery upload. Westville Prison cell block video, body camera footage during contact with Allen. That'd be awesome. Door sheets, other Westville, Indiana Department of Correction report and documents. One Western Digital 2.5-inch 2 terabyte SATA hard drive. So this right here, one Western Digital 3.5-inch 500 gigabyte SATA hard drive labeled as compilation data contained on 8110. The files on this hard drive contain, it's like February 17th, I don't know what that's saying. A Delphi flip phone found under bridge. So there's flip phone found under bridge, huh? Delphi LG found phone. So it's Liberty German. Delphi. No, it could be. Does LG make phones? Found phone Clinton County Axum Celebrite. White chip off report. Amazon tablet. Verizon Tower dump victim. Verizon Tower certification. So this is the Hoosier. And by the way, I don't know if you watched my interview with Holman. They had the surveillance footage from the Hoosier Harvest Store the whole time. Okay, it wasn't like they had to go back there and get it. That was misinterpreted when people were writing the notes. They had all of the surveillance already from the Hoosier Harvest Store. Hey, thanks, Sybil Bergeron. Cell phone extraction, Baker, Barger. So it looks like we've got one Seagate labeled as 811 containing security camera footage and photos from Hoosier Harvest Store footage from residences of 5998. Let's see where that is. And David McCain photos. Man, I'd like to see his photos. I mean, just any photos from that day are just interesting. So let's see where that address was. Oh, that's that address right there. That's the video. So it's showing that they got that video. And they decided not to use it. Why would they? That's just crazy, man. That was a stupid move on their part, I think. It seems like they could have used it like, well, hey, what the prosecution's telling you right now, that he got scared down there at 220 or 225 can't be true because of this. And then that one might make people have some questions, like about reliability or something. You know, like, But instead they didn't want to do that because it ruined their theory that perhaps the girls actually got into Brad Weber's van or something. You know, we want you to think that a little bit, but if we tell you that it was 248, then that doesn't work for that. 244 when it drove by in the camera. Hey, welcome, Tito. Or I guess you've already were a member here, but you're got the sheriff badge and everything. Thank you, Sybil Bergeron, and thank you, Death by Chocolate. And this is Erskine. I mean, it looks like they're just, this is really kind of saying what all of the discovery was that was given to the defense, it looks like. This says January 30th, 2024, so at least they had it for over a year minimum. So there you go. So this is a document proving that the defense had that video. That's really all this is right here. There's no other meaning for it. I just hope that they release a lot of this stuff. You know, we're seeing little pieces here and there. If you missed the beginning of the show, I'm going to show you these again. These are pictures of the phone as it was found at the crime scene. Look at how there is condensation or perhaps dew on the phone. That makes some sense. Look how wet the foliage is just in general on the ground there. So obviously it's very, very likely that some water got into the phone jack instead of some miraculous story where the information was, the phone was plugged into in the middle of the night, and 4 something in the morning, 5 in the morning, somebody plugs it in, doesn't move the phone at all, and then they sit there for 5 hours listening to the phone or something, just listening or whatever, while there's people searching around, and then they unplug it. Or does it make more sense that a little water got in there, condensation, maybe as it dried out, the phone has heat to it, right? So maybe a little water got in there, created the connection, and then over time it dissipated, and then it looked like it unplugged. It probably was just a slight connection, and then it just went. Makes way more sense. You can look it up yourself. Just say go to like ChatGPT or just type it up on Google. Can water make a iPhone appear to have a jack plugged in but doesn't? Something like that. Yeah, so you got that one. Then there's also this photograph. Thanks, this account. And then right there, see? Yeah, the part that's interesting is it's covered with leaves. I wonder if that happened. Did one of the girls intentionally start trying to cover that? Or did they, maybe when Abby sort of, got down on the ground, it kind of pushed some leaves on top of it? Because there was a shoe on top of that, right? And then there's this one right here. All right. Well, there you go, everybody. I think that's going to do it for this live stream. But in a minute, I'm going to put out the surveillance footage analysis that I did in that other case. The Cypress 3. You guys should. That one's pretty interesting. It's really creepy. It's really similar to Elizabeth Barraza, where this car is driving around, and then this person, in that case, I don't know if you guys are familiar with that one, but that's in Humboldt, Texas. Elizabeth, God, I can't say that. Elizabeth Barraza case is when she's out there getting ready for a garage sale in the early morning hours. It's not even light out yet, And a car drives up. It's been circling around, drives up. This person gets out of the vehicle, and it's a male, but the male's dressed in female clothing. Then walks up, says something to her, then shoots her point blank, then walks over, stands above her and shoots her again, execution style, and then quickly walks back to the car and drives away. And that was like 2 years ago, and it's, or maybe even 3 at this point, and it hasn't been solved yet. That's kind of similar to this Cypress 3 case where the car is driving around the neighborhood, then a person gets out, walks up, walks through a little park, goes behind a fence, goes into the back door, goes upstairs, and shoots 3 people multiple times, sets the place on fire after putting, I don't know, use accelerants or whatever, sets it on fire, and then leaves out that same back door, goes back to that vehicle that he was with, had another driver, and met him on this street, almost knowingly that he would be there right at that time. And then he gets in that car and drives away. So you'll have to check that one out here in a little bit, probably within the next hour, all right? So anyways, thank you all very much for being here. Thanks for those who supported the channel, even with the like button, if you could do that. So we had Who Knows, 13 months, Cindy, 26 months. Then we have Timothy Cecil, then Cheryl, 18 months. Laura, 60, 52 months. Oh, God, that's like, how many years is that? That's a lot of time. And then Kelly S., 20 months. Then Cheryl did a super chat. Then Sandy Shirley, 23 months. Kelly Snyder, Mary C., Lynette Eades, Jim Lawn, K. Me, Dickie D, Meatballs, Burner Phone. Then Death by Chocolate, Sybil Bergeron, Tito became a new member, and this account. Then we had Alex, CMAP, Stephanie, and Broyne all did coffees. So thank you. And if you're watching it later, if you want to send me a coffee, that'd be great. Just trying to make things happen this month, you guys. Just trying to make things happen. But anyways, thank you all for being here. Great job by McClellan in completely refuting and destroying the entire argument that the defense team tried to put out there. It's their own fault that they didn't use various elements in the case, and those elements themselves do not even prove that Richard Allen isn't the killer at all. Doesn't prove anything. So, thanks everybody. We'll see you guys later. And as I always say, until next time, be safe out there. Yeah, I've been doing this true crime thing for quite a while now. And during this whole time, I have not seen one person that is a crime dissector, rejector. I'm a certified human lie detector. There you go, Jim Long. Gonna get ya on a stretcher
if you try to play me like an old projector.
Crime sector is my
nectar. Professor Gray is gonna give another lecture. Crime collector, freak connector. I'm always gonna be a puppet deflector, interceptor.
And I'm meaner than a
Spectre with a vector
on his pector with
more respectrum. Just remember,
I have a temple fucking
projection.
I have no agenda. I'm no
Contender, God will serve it to you straight without the blender. And in the end, I'm gonna send you on a mission to reveal the true offender.
Yeah, so I'll just get right back to work. All right, everybody?
All right, everybody. Thank you, and be safe out there.